We've all been there, right? A promise is made, a deal is struck, and then nothing. When that promise is a legal contract, what happens next? Well, the law can't turn back time, but it does have a special toolkit designed to deal with the fallout. So today, we're going to open up that toolkit and see exactly how the legal system tries to make things right when a promise is broken.
Here's how we'll break it down. First, we'll look at the fundamental goal of any legal remedy. Then, we're going to dive into the main tool the law uses, which is, you guessed it, money. We'll explore the whole spectrum of damages. And finally, and this is super important, we'll cover the major hurdles you have to clear to actually get paid.
All right, let's start at the very beginning. When a contract falls apart, what is the law even trying to do? What's the end game here?
I mean, really think about it. A supplier doesn't deliver the goods, a freelancer misses a huge deadline, the deal is off. So when you go to court, is the point just to punish the person who messed up?
You might think so, but that's not it at all. In contract law, the number one goal isn't punishment. It's about achieving what lawyers call wholeness. The idea is to put the injured person in the exact same financial spot they would have been in if the contract had gone through perfectly. It's about restoration, not revenge.
So if the mission is to make someone whole again, how do courts actually pull that off? In the world of legal remedies, there's one tool that does pretty much all of the heavy lifting.
And that tool is money. Cold, hard cash. Courts award what's known as damages, a sum of money meant to compensate for the losses caused by the breach. It's the most straightforward way to translate that broken promise into something tangible.
And what's really cool is how this money can protect three totally different interests. First, you've got your expectation interest. That's the profit you were counting on, the whole point of the deal. Then there's your reliance interest, which covers any money you spent because you were relying on the promise. And finally, there's restitution, which is simply about getting back anything you already gave to the other party. It's a really flexible way to look at a loss.
But here's the thing. Damages isn't a one-size-fits-all solution. It's more like a whole spectrum of tools, each with a very specific job. To make this super clear, let's follow a simple story. Imagine you're a baker who ordered a custom oven for your busiest season, the holidays, and the company never delivers it. Okay, tool number one is compensatory damages. This is the bedrock, the absolute foundation of most claims. Its job is to cover the direct loss of the bargain, the difference between what was promised and what you ended up with. So for our baker, let's say the custom oven was supposed to cost $10,000. Because of the breach, they have to scramble and buy a replacement for $12,000. That extra $2,000 they had to shell out, that's their compensatory damages. Simple and direct. Next up in the toolkit, we have incidental damages. You can think of these as the cleanup costs. They're all the little out-of-pocket expenses you have to pay just to deal with the mess that the breach created.
You know, our baker probably had to spend hours on the phone, maybe pay a broker to find another oven in a hurry, or pay extra for rush shipping. All those little costs that only exist because the first deal fell through, yep, those are incidental damages.
And now we get to the big one, the one that can be a real game changer, consequential damages. These are the indirect losses, the ripple effect of the breach. This isn't about the cost of the oven anymore. It's about all the other bad stuff that happened because they didn't have the oven.
And for our baker, this is the true disaster, right? It's not the $2,000 for the oven. It's the tens of thousands of dollars in lost profit from all the holiday cakes and cookies they couldn't bake. That's a consequential damage. And as we're about to see, it's also the hardest type to get a court to award. All right, two quick specialty tools to round things out. You've got nominal damages, which is a tiny symbolic amount, sometimes just a single dollar, when you prove a contract was broken, but you can't prove any real financial harm. It's basically a you are right award. And then there's liquidated damages, which is the total opposite. This is where you actually write the penalty for a breach right into the contract from day one. It's planning for failure right up front. Now let's quickly clear up something that confuses a lot of people. Punitive damages are extremely rare in contract cases. Their goal is purely to punish a defendant for some outrageous, malicious behavior. Aggravated damages, on the other hand, are about compensation. The key difference is the focus. Punitive damages look at the defendant's terrible actions and aim to deter them. Aggravated damages look at the plaintiff's heightened suffering, like emotional distress, and try to compensate them for it. Punish versus compensate. It's a huge distinction.
Okay, so you know all the tools in the toolkit. You've figured out your compensatory, incidental, and consequential damages. You've got a number in your head. So you just send a bill and you get paid, right?
Yeah, you wish. It's not nearly that simple. The law puts up some pretty significant roadblocks. Just because you lost money doesn't mean a court will automatically make the other side pay for it. In fact, to win your claim, you have to successfully clear 3 major hurdles. Your loss had to be foreseeable, you have to prove you tried to mitigate your damages, and you have to prove your losses with certainty. Let's take them one by one.
Hurdle number 1, foreseeability. This idea comes from a classic case way back in 1854. It basically says you can only get money for losses that the other party could have reasonably predicted would happen if they breached the contract. So if our baker was secretly planning to use that oven to win a $1 million TV baking contest, they can't claim that lost prize money unless they told the oven company about their grand plan from the start.
Hurdle number 2 is mitigation. This is huge. The law demands that you take reasonable steps to minimize your losses. You can't just sit back and watch the damage get worse and worse. Our baker couldn't just throw up their hands and close the bakery for a month. They had a duty to get on the phone and try to find another oven. You can't get paid for losses you could have easily avoided.
And finally, hurdle number 3, certainty. You have to be able to prove your damages with, well, reasonable certainty. A court needs facts and evidence, not just wild guesses. This is the hurdle that often trips up claims for lost profits, especially for a brand new business. A vague claim that you might have made a ton of money just isn't going to cut it. So all of this leaves us with a pretty tough question. When you look at this whole toolkit of damages, but then you factor in these big hurdles of foreseeability, mitigation, and certainty, does breaking a contract stop being a moral failure and start looking more like just a calculated business risk? It's a question that really gets to the core of what contract law is all about.